You are still watching with all due respect extended version. And your questions to ask. And the questions I'll be asking are a form of breaking news. And I expect Makacham say, Mr. P, I told you to give me the number of female Supreme Court justices. I want to know. Because the question is going to one female Supreme Court judge. And that female Supreme Court judge maybe send about 7 questions. May man about 72 hours to respond. So I'll respond the questions now, maximum a week. So I'll respond the question now. I'll follow it up with videos. I'll follow it up with text messages, conversations. I'll follow it up with car numbers. Sir judge, dear, oh yeah. I am setting the grounds for this. Because and the yehunya maybe. Se papa anya shia, boni a friend boni, anya shida. I'll bring you the questions. I'll let you know oh yeah, female Supreme Court judge, because me sure say Ghana Supreme Court your judge for me you are all supposed to pay attention to this, because mumu bako and a question we ekwamano. All right, now you see and they call court, so I'm for ya tin sembebre say and there afenyo marking MPP for court asana ko Supreme Court Emma Sebio or Kunya or the ex-party application because Supreme Court say Speaker of Parliament Alban Bagbin why a debut of Parliament we ye MPP phobia almost independent we ye omoto akonyanti NPP minority leader afenyo marking Supreme Court catch Chief Justice say Chief Justice Juma dia omudino Parliament Chief Justice entuni na nsim if you say Chief Justice na betuma aboa no afenyo marking court Chief Justice onim Parliament omusu dwumadi omudia sebio omudi omho no otuni nan na odi sim say decision bia Speaker of Parliament Alban Bagbin eteki no Supreme Court Chief Justice tokonu edi enimu no ono wetuni nan sim judgment ana ruling na oma Parliament say NDC for from time or massa judgment my majority Chief Justice Sebio judge for mo omotu omu na esim asamono Alban Bagbin so be 2 days ago ono so ehu krata Supreme Court for the bre no kire ne say decision wo dwumadi a within the Parliament even though mo independent body mo aso mo hyemra make sure say Ghana na ye chechire no bibia koye no omo wo akwanya say omo betu omo na esim. Alban Bagbin also received this suit from the Supreme Court, and our directing the lawyers say omo ko Supreme Court ko kan kire Chief Justice say dwumadie na odi no Supreme Court no saa tumi na ekuta no ono Alban Bagbin ne Parliament so the same to me, the same as the executive ne wanwa say asema AC Parliament asema Parliament eka omankasa betuma tenase aka Parliament wo ono ankasa ne mra obetubedi so ahyehye mra no se Parliament kura asem siwo na se sebio omo nti omo ho ase a omo wo bibia ye frɛ no rules and regulations standing orders a omo betumi de asolve asem no o say Chief Justice etumetu ne nan esi omo asem no ohun ne se Chief Justice watra nani nton sebio ni tumi no Oma ni tumi no atra na no sebio oma ni tumi no atra nechi sebio oba na tebe mudodo. In fact emrana Chief Justice ejina so edi akase onja ni dwumadi a odi no Parliament no mra bia etia Ghana mrakase constitution no. Yes. Okay, thank you very much. I will use that. The 5 Supreme Court judges, ayemba, 1, 2, 3, 4, 5. 5. I'll mention their names now. Assembly Sakopie Court, Alban Bagbin, Esman, the lawyers, Momo responding to Supreme Court, a court Chief Justice war. Now, and the Assembly P Court, TV so. Me assure say from Ochina let me land the phone be beba. Abetu to brofo akese jargons so amefo ntina me yewe nkame nye so amefo ntina me yewe now afenyo marking Supreme Court ko kan asem kire osono maame eye Madam Tokonu a ogine mu ma MPP o eye Supreme Court no okono asema ode call eho nyina ne say eye de let me put this picture up na yenko yenim. This is the Chief Justice and ono ena Ghana Supreme Court no odi enim. Afenyo makin ede na asem ekọ Supreme Court no okoka kire Chief Justice say eye nipa miensa bia omo parliament ena Alban Bagbin atwe omoto ase akonwa se omo ko independent dia eye akonwa na ewo ho no sebio omo ja akonwa na to eni se omo from se omo ye MPP MPs na emom omo ye independent. Now afenyo makin koye no inkura na nka oso kobo Chief Justice no they see your parliament and say eye nipa 9 MPP form yensa ena NDC ni baako na so afenyo makin eko eye Supreme Court no or the nipa miensa din ne call ye say sa nipa miensa we nkoa na eye Speaker of Parliament ehwe ho bua asem of Parliament na so ukọ Parliament nkrata mu a Parliament nkrata mu no sa da na eye Alban Babin ebu asem no na eye nipa 9 enho asem ena ogina so ebu a na asem na so afenyo makin eko Supreme Court na okoka na asem a kire eye Osono Maame eye the Chief Justice no okoka chen say nipa miensa it means say in the first place the ex parte application na afenyo makin edico Supreme Court no that application no everything in it was a lie because don't say court okokota in sem na yede ko yenyi bi mfrim ene enfa bi nka ho afenyo makin court no o decide say inkuro ananyoma ekoso parliament ema Alban Bagbin gina so ka say 4 MPs yi omoto akonwa efiso omoko independent no ono free parliament ede na asem akọ court ede akọ Osono Maame ho no o say nipa miensa enho asem na Alban Bagbin gina so ede bu asasem no court so anase eye imrahwe Supreme Court Madam Tokonu Osono Maame da ano no eye facts ene ede gina so ede bu asem. Now the ekosi nyina ne say asem na kopie court na ene the epie court nyina ne say Alban Bagbin show letter come Supreme Court Chief Justice say uni ho kwan in fact muni ho kwan krampo say the ekoso parliament no mubetu munan esim enti enho ena and the Chief Justice eye Osono Maame Madam Tokonu ene the battalions miensa maka no etena ase say omu bebua sa asem no ansana asem ankasa afenyo ma kende baaye say Chief Speaker of Parliament say eye omu ye minority anase we yi MPs miensa to akonwa no yakoso into the end ekoso no nyina ne ye interlocutory issues eye fa asem no ho e de say we twa material enwa ahoma no enende eye Osono Maame Madam Tokonu ene the battalions no etena ase edi hu enkomo enti adekudie nti omotena ase ndan se na omopese omotie Alban Bagbin se bi oni response de bro mo se omuni hu tumi krampo se omobetena asem no so na omotena asem no so no eye Osono Maame Madam Tokonu ene eye the Supreme Court judges omaka baako ye MPP foot soldier your friend eye gawu anasa de mebodi din eye Nansia Nekufuado eye the Supreme Court judge na obi anim so oye former MPP parliamentary candidate Ghana ni mako Ghana ni mako mo Supreme Court judge oye former parliamentary candidate ema political party in power e de akurofon so no now yonko enim inti eye lawyer ogina muma Speaker of Parliament eye Theodore sorry one eye Attorney General onu so gire mu ma Ghana ena ende omu nyina ekopie eye de Supreme Court. Now ye kika asem ni nyina besie no na as a Chief Justice person o kire se owo hu tumi Supreme Court ni wo hu tumi se omu ye de omu pe omu frɛ Alban Bagbin the decision bia o taking wo o taking wo eye parliament bia no omu wo hu tumi in fact constitution ma omu ho kwan se omu betu omu ndan sim na omu akire de o se parliament eye enintina omu pese omu koso no omu kodi asem na nkasa intende no dia de kodi enti omu tena ase ne se Alban Bagbin mu aye o de bro omu se omu ni ho kwan se omu bedi asem no omu se omu abo atogu omu ho kwan na ensem no se ne ebobo baaye no moma yenya abotre na yentie sene ye ko ye sene be asoamefo enso beti asie pefe ansana please let me land. I know you are my elder brother. We all went to law school together. You have been a friend for a long time. We know your party affiliation. Ansana sankwasi afora ba ochna. Enti ye ne local ejudwom basic. Na ya mama hu de si wo Supreme Court nde. Na ya kire mo sene osono maame Madam Tokonu ejina pintin kan no totwom ye na adwun so obeye adwuma amekufu ado. Na sebio abomu thank you. Ekufu ado ye Chief Justice no or the man the back. Now, so ko de si wo court na. Time my Chief Justice kasa no. So wotie Chief Justice here. Uhwe enkrata afenyoma ken de call Supreme Court ene ne starting free. Ye de yen call law school but your common sense. Ene na we Ghana ni na wo hwem a you don't have to forget. Unko law school and chese nyansa unibi. Ena sebio ye kan asema se court o se out of court o se ye mra o se nya mra o. At the end of the day, everything dwells on common sense. And you don't have to be a PhD holder. You don't have to be a lawyer. You don't have to be in law school to understand fundamental or basic reasoning and logical reasoning issues. And you don't have to struggle to use your common sense. And I make a say on this platform, what we try to do is say we bring everything down to the basic reasoning level. We are Ghana and Utia because asem we de emunyansa no ene dien adentina simesi we ye say anything every time we bring the conversation to your level. Inti brofo mo kekan bebrebe o court nde no me ena mabetena ha ne me team ena ye de ba for ma wate ase because na ye Ghana ni a wokoto aba wo taxes ene ye di tuan kofo mo te court ne ka inti I was said ye course court no so no at the end of the day no oye den wote ase. Okay, now there's one thing you need to understand. Say I'll be to court and I'll be to parliament. Eka constitution 1992 constitution. I was so bibi and there's one thing I Ghana for mure yefi. Ghana constitution a mason for a hairdressers, a welders, a ma omoton adwini wodwom, omoton apofe, a tailor for a student, a teacher for a different kinds of artisans. Ghana for ordinary Ghana for ne agi o madwene e de chichire ana de chiro constitution. Enti nobody in this country should see the constitution say you to free wiem na baye 1992 or before 1992 no nipa bi ene to omugu Ghana impenifo mo Ghana ene omje Ghana for adwenkyere efa nyoma ana sene omo pese ye chichire Ghana. It is the constitution and that's what the constitution of Ghana. The constitution of Ghana. And your brony be na de baye. Eya wona ana maame ana papa bia e bia wetwam ana wawu ana yempanifobia na mo ho ani eni ho ana mo amoda wote ase ya dwenkyira ya gege ya kekese ani na de build bibia for the constitution. It is our constitution e ho no enye some book bia bi nsi da eya mene wo adwene kyere and the friend constitution. Adwene kyere a ebeboa mene wo e de aboye ho ban abo oman ne ho ban e na ye nyina e de atokrata so e friend the 1992 constitution. And do not think say eye osono maame Madam Tokonu or some exceptional being be a constitution or no kwa na wo ho kwan say o kyerɛkyerɛm tie mema wa adwene nya wo say politician biti radio so na TV so a ono enkwa na nyankopon ama no ho kwan say eye 1992 constitution a tailor for mason for hairdressers eye doctors teachers obi a oye Ghana di bia e de na adwene kyerɛ ba ekyekere no omo nkwa na wo ho kwan ye nyina wo ho kwan say constitution no ye be kan na ya te ase na ya mana boy nyina ho ban. So do not see yourself say constitution de asuo na nipa bi nkwa na wo eye entitled to break down or explain the constitution and a majority of you Ghanaians they deceive mu abedru nne. Nobody is entitled to explain or interpret the constitution than the Ghanaian. Some people have been given the mandate that officially when there's an issue they can sit and make it official, but we all as Ghanaians, unofficial or official, we have the right to read the constitution and interpret it. And the basic thing is that we need to be reasonable We need to reason. Our reasoning level should be to the point where we can read the Constitution and understand the Constitution. So if somebody is misapplying the Constitution, you and I, I will see a transcript as a dabi. Constitution we nurse ni na chiro Constitution we tailor ni hairdresser inti ya ma wo nkwa mbe wa adwene se wo na wote ase. So we should all understand this. Over a period of time no nipa bi create ade bi ato Ghana say yo nipa ko bi a omunkwa na read the Constitution. That's not how it's supposed to be. Yo nipa ko bi a omunkwa na entitled to speak on the Constitution. That is not how it's supposed to be. The Constitution should be a basic document. Every Ghanaian should be able to read and understand. The one ko school kra an kenkan on to mean kind brofono. I will see a to me mani panati Constitution. That's if you say a sani pana one ko school no na drink e ka ho and a mayor year day ye di Constitution by 1992. JJ Rawlings edi ni me de bae. Inti enya Rawlings nko adwene. Enya asimesi nko adwene wo eneme. Inti about Constitution mama ye common sense ni nye adwuma. Mama me emfa title ne nko ama judge for. Mama me emfa ma politicians. Mama me emfa ma nipa bia. Oma adwene yo mo say because they are in politics they have the right to interpret or only speak on the Constitution. Na ye maame na oye hairdresser no. Ye nua na oko school no. Ye nua na oye welder no. Ye nua na oye mine ni no. And I say ye nua bi na oton nyama na otumi kan no. Only right. We all have the right to read and understand the Constitution equally. What am I saying? Now, let's move forward. NOB Kano, the Constitution of the Republic of Ghana should be added to the syllables of Ghana schools. I will say I will say a part. And I remember when we were in school, social studies, we had some part of the Constitution in that book. But in Kwasiafo we started school we don't even know anything about the Constitution of the Republic. I was from class 5. You started the Constitution, you were a Constitution subject. I was saying your school you the Constitution Sibiani reading books bit say life skills book, social studies book, Arabic book I was say Constitution a topic. Enkorano ebe read the Constitution. Teacher ni beba kenkan page by page. Ondu JSS3. Now on every part of the Constitution of Ghana. It should be part of it. And I expect the incoming government to introduce this. Add the Constitution to the syllables. Enkorano from class 5. We need to infuse the Constitution in our day, in our daily life, in our education. So I expect the NDC government, when God helps them to come to power, they should infuse. Professor Nano Pokwajimamu should insist that the Ghana Education Service add the Constitution, makes it a whole topic on its own. It should be a subject. That we have the Constitution as a subject. That every kid, by the time they get to JSS3 or junior high school 3, that kid knows about the Constitution, every single page of the Constitution, so that we, the ordinary people, they call us, we can also defend ourselves. Because that gap and then some judges, some lawyers, some stupid criminal individuals in Accra sitting on TV, intimidating you, the Ghanaian, and taxes Ghana. So we need to make sure the Constitution is it becomes a subject in school. We need to be distributing Constitution book to the kids. The schools need to have it in school. I will say a chema obienya 1-1. Now edu Constitution subject. You're reading the page by page. And then your page 23. What does it talk about? Chieftaincy affairs. The kids needs to be taught, or they need to be taught the Constitution. They need to be abreast of the Constitution. They need to know what the Constitution entails, so that as they grow, kwasiebin to mean free Holland in Bambeka say, or school Holland, or Bedi Ghana ninso. We need to get these things right. And I will plead with Professor Nano Pokwajiman that she should add this to her conversation. She should tell the people that when the NDC government comes to power, the Constitution will be a subject in our primary schools all the way to the senior high schools. That's how it's supposed to be. We need to teach the Constitution in schools. All right. Now, team, stay with me. Inti under court, they see any. Now, the first part of the CEO court. Now, me bechira debi. Afenyo marking ne ex-party na or the court court no. Ex-party application na ono kwa court one fre obi anka ho okoye no. So what kind of document ni ye because ende no Afinyoma can call court no. The last time no, or catch the Supreme Court to say ministers and MPs me and someone some and so oko parliament document moi a MP for a 9 wasem and Alban Bagbin a rule make sure how inconsistent the Supreme Court is, how they don't take details seriously because of corruption. You see, when you are corrupt, what you do, then they say, you always try to cover up details. And what most corrupt people do, then they say, because details are important and details majority of the time expose corrupt-minded individuals, you know, they try to give less attention to what we call details. It is Osha Afinyoma can call court, you know. He was talking about 3 MPs, and so over Parliament, Adia Alban Bagbin Jina so take a decision now. It was about 4 MPs. In the first place, you know, Afinyoma can Adia Jina so call court, you know. It is wrong. It is a lie, and the Supreme Court is not supposed to entertain it. Into the case, Krano in the first place was not supposed to be called. The Supreme Court was not supposed to entertain Afinyomakin. Into reading Afinyomakin, what we call the ex parte application. The second point now, or say, an order restraining the Speaker of Parliament from pronouncing on any motion in Parliament directed by Right Honourable Andrew Esiama Amwako, the current Member of Parliament for Mena in the Ashanti region and second Deputy Speaker of Parliament, Honourable Cynthia Morrison, the current Member of Parliament for Aguna West in the Central region, and Honourable Kojo Asante, the current Member of Parliament for Suhum in the Eastern region in the current 8th Parliament of the Republic of Ghana, from vacating their seat on grounds of leaving his political status as an independent candidate at the time of his election to Parliament to another party, and leaving the party of which they were members at the time of their election to Parliament to become independent members of Parliament respectively. Inti uche Afinyomakin adia ojina so ede court no in the first place ko kire Madam Toko and Madam Toko jitu mu na Afinyomakin went with 3 MPs. I'm trying to take this off. Sorry. Afinyomakin call no okokache Supreme Court say MPs miensa mo MPs MP na ema Alban Bagbin Jina so ebu asem no enso ukọ parliamenta na MP se 9 omo ho asem ema Alban Bagbin take a decision or take here no. Into what will make the Supreme Court take half truth and try to judge or make a ruling on half truth, because you cannot go to court with half truth. And it's when you go to parliamenta, you will see this. I'm trying to get you everything. Mama yanko tie the Chief Justice and the Supreme Court timer Speaker of Parliament the lawyer Kasaye.
And so that was taken into account before the court makes the extensive orders relating to even 4 parliamentarians when the writ itself affected 3 parliamentarians. It didn't even include Article 97 1 each. And so all of those orders were made based on some of those findings. And I'm saying that, and the position is that the first defendant, based on these things, expects that in order not, especially when the court reaches a conclusion that on the balance, there was no balance, there was just one side of it, because it was an ex parte application, and they were ahead. What was the balancing? Sorry, yes. I think we are just responding to a very straightforward. Oh, yes. But now the case that we are peering into the substance of the motion itself, I would urge you to restrict yourself to the objection that and answer it, whether it's scandalous or it's not scandalous. This is not scandalous. My problem is that if your learned friend on the other side has raised these matters and you think it's not scandalous, you don't have to, as it now, peer into the substance of the application itself. But I needed to demonstrate that these things were not just said at a just restrict yourself. I thought I was doing that. And so, the surprise and concern, apart from the use of the word scandalous, which he just used. He doesn't demonstrate how scandalous it is based on the context of the applications that I have before.
He alleged that the Chief Justice is privy breach of a constitutional provision. What are you trying to convey?
It may have been by reason of incompetence. But if that is a statement of facts,
was it necessary for you to add that in your depositions for you? What exactly were you trying to achieve? By adding the point that the Chief Justice was privy to a constitutional breach. I think that is the point it was.
Oh yes, but the point is that if she was privy to it, her ruling must reflect that. If it doesn't, it's one of the grounds upon which I'm urging the court to set it aside.
So, Speaker of Parliament lawyer, the Okache Supreme Court in say, Afenyomakin Baha Abekase, MPs me and San Wasam and Alban Bagbin Jina so Ebua Nasam or speak Parliament. Nanso anya no kre. Nipa ye come wasam omo ye 9. Inti eden na Afenyomakin eba Parliament, ebedi eba Supreme Court, ebedi atrochre mo say nipa miensa. En wasam na Alban Bagbin ejina so ebua say NDC majority. Ena judge for mo to say oh na asana wo ka no ye pese ebusa say den na wo ka say Chief Justice Krampo no de oyeye no entwa ye omo ntia say obi beka say Chief Justice take decision bia sad decision no scandalous entwa ye into omo problem no say the word scandalous omo problem no say aden na wo ka say Chief Justice decision bi o take ye no based on the Afenyomakin de buy no entwa ye enti de enti na emane kasa. So Chief Justice Akasam entwaye and it's not even Supreme Court it was something we call review and it's not your appeals court because you a court no it's not perfect. It when somebody says the Chief Justice took a decision and that decision technically it was scandalous, it was basically and it was basically the ruling was not based on the facts because the facts and they say when you go to Parliament 4 MPs in 170 eka. Afenyomakin the MPs 3 in 170 buy. So it means Afenyomakin brought a lie for the Chief Justice to rule on. So for the Chief Justice failing to make sure the details are right, the Chief Justice has committed a crime and it's scandalous because we expect the creme de la creme, the biggest court on the land, to do its checks, dot its I's, cross its T's before it makes a judgment. Finished. So how can we be here that we are dealing with half truth? No, because after Afenyomakin in Parliament, time Alban Bagbin eka say MPs and 9 abaku free NDC miensa free MPP we you omato akonwa no ade achi no Parliament krano they were supposed to do what? They were supposed to in fact draft into Alban Bagbin ruling no na e was a Parliament e de ko enkra time into redia so oko Parliament documentation mu a there was a memo Alban Bagbin from Parliament no release here after Afenyomakin court no 21st of October 2024 editor of database chamber reporting office of chamber reporting memo say pursuant to regulation 551C and 0 of the Parliamentary Service or Staff Regulation 2019 CI 118 explain why a disciplinary action should not be instituted against you for photocopying the drafts Hansard of Thursday 17th October 2024 and making same available to some other persons without authorization. Your response should be submitted to the editor of database chamber reporting by 4 p.m. on Wednesday 23rd October 2024. Inti the CNSA after Alban Bagbin making sa declaration or Parliament what happened and they say sa declaration at the end of the day everything that happens in Parliament it was say wie na yehu se mistake bi animu a na eden speaker sign and sign a official document. Now the moment ye beye bibi o Parliament yen sign ya speaker engine tumu entimu so no it is a draft enye document sebio obi abetuma gina so take a decision into that ruling from speaker no that ruling was not a complete statement and I say a confirmed ruling from speaker. If you say now the ruling now make it was supposed to be entered into the document in Parliament to make it an official ruling. Now what happened and they say adeɛ bɛkyi no ɛna ɔmo parliament no be a printed the ruling that has not been officially endorsed to be an official ruling no and ɔmo de ma afenyo making so on fanko court. Inti ema speak any break ka say document now de ma afenyo making coin a draft document. Na autumn draft document edemo obi so on fanko court if you say adeɛ chia every time they sit in parliament what they do is they go through all the things they did the previous day and see say if there was a mistake somewhere they correct it. After they do the correction, then it is endorsed to say the previous meeting has been endorsed to be an official or valid document. Afenyomakin took a draft document that has not been endorsed by Parliament into the document Afenyomakin took to the Supreme Court. Now, sad document, and yet they're in the final document of Parliament.